Tonight on Newsnight Scotland, when it comes to safeguarding our human rights, should we turn to the UK Supreme Court or go straight to Strasbourg? We'll speak live to the First Minister. And we're told those with the broadest shoulders will pay the most. So why are some of the most vulnerable getting massive hikes in the cost of care services? We have a special investigation. Good evening. Should the UK Supreme Court have a role in Scottish criminal cases? That's the question the Scottish Cabinet has asked an expert legal group to decide. In a meeting earlier this evening, the Cabinet said the group would bring forward proposals to be debated at Holyrood within weeks. This judicial row all started last Wednesday when the UK Supreme Court ruled Nat Fraser's conviction for murdering his wife Arlene was unsafe. The First Minister and his Justice Secretary voiced concerns about the role of the court based in London. But does all this miss the bigger picture? Shouldn't we be examining why some major Scottish court rulings have failed the human rights test? We'll ask the First Minister in a moment, but first, here's Laura Bicker.
The very nature of the Scottish legal system hangs in the balance, and the First Minister would have us believe this court is to blame. The row centres on this case, the mystery of Arlene Fraser's disappearance. Her husband Nat was convicted of her murder in 2003, but he appealed, arguing prosecutors had breached his right to a fair trial. Last week, a panel of 5 Supreme Court justices unanimously agreed.
The Supreme Court unanimously allows the appeal. The question which it had to decide is whether there is a real possibility that the jury would have arrived at a different verdict.
This angered the First Minister and his government, and now they want the Supreme Court to have no role in Scots criminal law, an idea some find ridiculous.
I think the Scottish Government's shooting the messenger, and that messenger is the UK Supreme Court, because the UK Supreme Court is doing us a favour in Scotland by dealing with human rights points in a very fast and efficient way. And if it didn't do that, it would take several years for the European Court of Human Rights to do the same. Now, it's almost like there's a kind of a Brigadoon bubble that Scotland's a perfect legal system, and the Scottish Government doesn't like the fact that we're being criticised or held to account. The reality is, no system's perfect. Scotland's system has a lot of strong points, but equally it has a lot of weaknesses, and somebody needs to point them out to us.
The Scottish Government say an alternative would be this court, the European Court of Human Rights in Strasbourg. But what do they know of Scots law?
It might take 4 or 5 years. That court is severely overloaded with a workload at the moment that it can't really cope with. There would be a greater degree of uncertainty for those who are wrongly convicted, but also for victims and witnesses as well.
It's true, the Supreme Court has put pressure on Scots law in the last year. The Nat Fraser ruling was the latest. Last October, the Supreme Court ruled on an appeal brought by a teenager, Peter Cadder. It means Scottish police can no longer question suspects without allowing them access to a lawyer. Alex Salmond has decided to take the Supreme Court to task. Critics say he's turning these judicial decisions into a constitutional crisis.
The reality is, there's so many things wrong with our system at the moment, and there's so much we could do to put that right. Scrapping the Supreme Court in London ain't one of them.
The First Minister's next move will decide the kind of justice Scotland will serve in the future.
That's Laura Bicker there, while the First Minister Alex Salmond joins me now from Edinburgh. Good evening, First Minister. Thank you very much indeed for coming in.
Good evening.
First of all, what are the range of options that this expert legal panel do you think will consider?
Well, the expert panel will consider everything from immediate action. An early example of that would be to only have the Supreme Court intervening, as is the case in England, incidentally, when the High Court gave leave to appeal. The remarkable thing about Scotland is the Supreme Court can only intervene in an English case if they're given permission or leave to appeal by the appeal court. That would be an early thing, or more fundamentally, and here I take extraordinary issue with the contributors to your film, it would be a simple matter of setting up a bench in the High Court which could specifically look at human rights cases. You know,
a bench in the High Court in Scotland.
The High Court in Scotland, which
taken
is
from the same judges who failed in the Cadder ruling that was the Saldus versus Turkey jurisprudence that came out of Strasbourg.
Well, how do we know they failed, Isabel? They failed according to a ruling of the Supreme Court. We don't know what Strasbourg would have said.
Well, we know what Strasbourg said in Saldus versus Turkey, from which this flowed.
Yes, okay, and if you think it's an exact comparison to compare a long-term detention and torture in Turkey with a short-term detention of a matter of hours of, say, in Tomatul, then that perhaps would be a sensible point to make. But most people would see a substantial distinction between torture in Turkey and criminal law in Scotland. And of course, the whole range of protections that are built into Scots law would have been given the opportunity to be examined to see if they properly protected human rights. But the idea that you need a court with a majority of judges from England to tell us how to implement human rights in Scotland, I think is an extraordinary way or belief for any Scots lawyer to have. I mean, after all, the European Convention on Human Rights was written by a Scot, David Maxwell Fyfe.
So, First Minister, you would rather substitute a court in which there are no Scottish lawyers at all, and in fact only one English judge?
Well, I think that's a misunderstanding. Firstly, of course, Lord Reid is a Scots lawyer who serves as a Strasbourg judge, Isabel, but we'll leave that to one side. That's a fundamental misunderstanding of the situation. Firstly, if we want to have a specific bench to consider human rights cases, we can set one up in Scotland and do that. But Strasbourg exists over all jurisdictions, some 40 jurisdictions across Europe. The case for having a Strasbourg backstop, implementing a convention written by a Scot, as I've just said, it would be to put Scotland in exactly the same position as any other self-respecting jurisdiction across Europe.
Right.
That seems to me not an unreasonable point to put forward. And secondly, of course, the big difference between the Strasbourg court and what the Supreme Court is doing is Strasbourg can't strike down convictions. Strasbourg court doesn't open cell doors and allow people to walk free, and certainly doesn't do it without a proper examination of the degree of protections and checks and balances within the Scottish judicial system.
Yes, but First Minister, in any of our courts, in the High Courts in Scotland, before you get to the Supreme Court, if any human rights decision is incompatible with the Human Rights Convention in Scotland, as you know, and whereas not the case in England, in Scotland, you can strike, the courts will strike that down. So there is a different relationship already. But what I'm asking you is how would you reply to some lawyers who say, actually, your concern should be, First Minister, that the Scottish bench and the prosecuting teams are insufficiently in tune with Strasbourg jurisprudence. That's what the real concern should be, surely.
No, I mean, firstly, on your paraphrase, why is that, Isabel? Potentially we have a situation because of unforeseen consequences of the Scotland Act. And I was in the Commons when it was passed, incidentally, Isabel, and I know these consequences were totally unforeseen, where we've had over 10,000 devolution minutes minuted in the Scottish courts, because people see an opportunity to say that everything is a devolution matter because it involves the Lord Advocate.
Yes, and we've had an average of one criminal appeal before the Supreme Court.
I was correcting,
a year.
I was correcting your paraphrase before you asked the question. What I then was going to come on to was to answer the question. Yes, it's true that the Supreme Court have only pursued certain cases, but the cases they've pursued, not so much the Nat Fraser case, which is incidentally a live case, and I don't particularly want to discuss the detail of, but the Cadder ruling had consequences for thousands of cases across Scotland, and fundamental consequences for the Scottish legal system. It may turn the entire criminal law system of Scotland on its head. And if we're actually going to do that as a country, I think we should do it with a free debate of how we want to protect and modernise our criminal justice system in Scotland, not because a court with a majority of English judges says so, and overrules in the Maclean case 7 High Court judges in unanimous finding in Scotland.
First Minister, the Law Society, of course, is arguing that what we now need is actually an audit of all Scottish criminal law to make sure that it can withstand these sorts of challenges. Would that not be a more constructive way forward? An audit which should have happened, actually, when the Act was incorporated in '98. Well,
actually, there has been an audit a few years ago, Isabel, but I mean, that is not necessarily... Well, Isabel, I was going to answer the second part of your question. That's not necessarily a bad proposal, and I'm sure the expert group will want to look at that. But let's look fundamentally at the crux of this issue. We have a situation which was never meant to arise. Historically, as you're well aware, the courts in England had no jurisdiction over criminal matters in Scotland. It was enshrined, for example, in the Act of Union that was the case, Article 19, if I remember correctly. We now have a situation where a court in another country is looking and intervening aggressively in our judicial system. Now, either this happens when a majority of judges on that court from other jurisdictions take action, which is questionable, or alternatively, it's because they're following the 2 Scottish judges on that court. In the most recent case of Nat Fraser, 1 Scottish judge gave an opinion. Now, I don't think it's sensible, fair, reasonable in any jurisdiction to have a situation where 1 judge is overruling the opinion of many judges in another court. It's all very well for people to criticise judges in the Court of Session, but why not criticise a situation which boils down to the potential replacement of Scottish law with Lord Hope's law? I don't think that's a satisfactory situation, and I think the issues that arise from it, in the interests of people in Scotland, are both far-reaching and require to be corrected.
First Minister, thank you very much indeed for that. Thank you.
Great pleasure. Thank you.
Now, getting out of bed, personal hygiene and getting dressed are things